But the Supreme Court's aversion to 21st century technology actually made things a little bit easier today, because when the audio was finally posted, everybody knew to skip right to the 51-minute mark so they could hear conservative Supreme Court Justice Antonin Scalia making this rather remarkable argument about why he thinks Congress voted almost unanimously, and unanimously in the Senate, to reauthorize the Voting Rights Act 6 years ago. This is why he thinks they voted to reauthorize this landmark law that protects minority voting rights. Here's how he explains the vote.
This last enactment, but not a single vote in the Senate against it. And the House is pretty much the same. Now, I don't think that's attributable to the fact that it is so much clearer now that we need this. I think it is very likely attributable to a phenomenon that is called perpetuation of racial entitlement. It's been written about whenever a society adopts racial entitlements, it is very difficult to get out of them through the normal political processes.
I was wondering if it would be on the audio, if you'd be able to pick it up on the audio that they released. That it turns out you can't pick up on the audio that they released because it's too tight from the microphones, it's not ambient enough. The things the mics apparently did not pick up was the audible gasp that you could hear in the courtroom after Justice Scalia said the words racial entitlement, the perpetuation of racial entitlement, after he suggested that voting had become a racial entitlement in this country that Congress can no longer make impartial decisions about. What the Supreme Court heard arguments about this week was a challenge to the Voting Rights Act of 1965, specifically Section 5 of that act, which requires that certain states, mostly in the South, but not entirely, have to get pre-clearance from the Justice Department before they're allowed to change their rules around voting. These are states that earned special scrutiny when it comes to voting because of a history of racial discrimination when it comes to voting in their jurisdictions. Since the Voting Rights Act passed in 1965, Congress has decided 4 times now, and by very, very large margins each time, to reauthorize it, to re-up it. They have determined that there is enough of a threat to minority voting rights in this country that this law should remain in place, and that this particular remedy within this law should remain in place. Congress studied this for months, as recently as 2006. 10 months of hearings. They gathered 15,000 pages of evidence. They held more than 20 hearings in Congress to decide whether this was still a problem and whether this was still an appropriate remedy to the problem. And they decided that, in their judgment, the Voting Rights Act is not just a good law, but a necessary one. All of the senators from all of the covered states who voted on it voted unanimously that it should be kept. And the argument presented against it this week by Justice Antonin Scalia was essentially, when they cast those votes, they didn't really mean those votes.
This is not the kind of a question you can leave to Congress. There are certain districts in the House that are black districts by law just about now. And even the Virginia senators, they have no interest in voting against this. The state government is not their government. And they're going to lose votes if they do not reenact the Voting Rights Act. Even the name of it is wonderful, the Voting Rights Act. Who's going to vote against that in the future?
The name of it is wonderful. It's disgusting. Justice Scalia, as you could probably gather, is almost certainly a vote against the Voting Rights Act, apparently on the basis that he believes it's some racial entitlement that Congress is too scared to get rid of, so we should take it out of their hands. You could also tell during the arguments this week that even though he does not have the reputation of being quite as purposely inflammatory or confrontational as Justice Scalia, the Chief Justice of the Court, John Roberts, is just as, if not maybe even more hostile to the Voting Rights Act. A good chunk of his career in government before joining the court was aimed at gutting the Voting Rights Act when he was a lawyer in the Reagan administration. So in terms of what's going to happen here, in terms of counting up the votes on the court, if you count Justices Roberts and Scalia, and Justices Thomas and Alito, who almost always vote with them, if you count them as pretty certain votes against the Voting Rights Act, and you count Justices Ginsburg, Breyer, Kagan, and Sotomayor as votes for it, and again, this is just speculation, this isn't certain, but let's say we start with that, then, as usual, you got one man in the middle. You got the swing vote on the court, Justice Anthony Kennedy, who, of course, everybody is watching. If all goes as expected, it will pretty much be one guy deciding the fate of this cornerstone provision of civil rights in America. The cornerstone of American civil rights law that has protected minority voting rights in this country for more than a generation, that has protected those rights in a particular way to be especially attentive in areas of this country that have had the worst abuses and that are seen as being the most vulnerable. if the court's decision is going to be that close, if it's just going to come down to one guy, does outside pressure matter? A lot of people think a lot is hanging on this decision. In terms of the way people express themselves about that, does it sway the court in one direction or the other? Because there is outside pressure on this issue. I mean, this was the scene outside the Supreme Court on Wednesday as the Voting Rights Act was being heard inside. Demonstrations by groups including the NAACP, demonstrations by residents of the county in Alabama that is at the center of this particular fight, folks who are relying on that law to keep their voting rights from being infringed on. This Sunday, a different kind of pressure. Vice President Joe Biden will travel to Alabama, to Selma, Alabama, to commemorate the Civil Rights March that took place in that city in 1965 that led to us getting the Voting Rights Act in the first place. This law is something that came about because of public demonstrations. I mean, the Edmund Pettus Bridge and John Lewis getting his head bashed in happened on a Sunday. The following Monday, 8 days later, it was LBJ addressing Congress, a joint session of Congress and a nationally televised speech demanding this law. The Voting Rights Act happened because of demonstrations. It happened because of Selma in 1965. Can public demonstration now have the effect of helping to save it?